Hi, Dana Sparks with Maximum One Greater Atlanta Realtors. This week's contract tip, and continuing with our series on the 2016 GAR contracts, has to do with a new consumer brochure that GAR just came out with. It is called What New Landlords Need to Know About Leasing Property. Now, before you turn off the video, because you never do any leases, just pay attention to a couple of things. There may be a time where you have a seller, a past client, who doesn't quite want to sell their house yet, or they want to sell their house, but they can't get the equity out of it they need. So they think, well, you know what, let me just rent it for a year or so until I'm in a better position or the market's in a different position, and then I can sell it. So that's really the person that this brochure is intended for, but it is great information for you as an agent to have that discussion with that seller, or even if you've ever helped anybody with a lease, just so that you know what's going on. I'm not going to go over the entire brochure with you, but it is a brand new brochure, B8. A great document to send to any sellers that are thinking of this. But just a couple of the issues that GAR highlights in this consumer brochure. First thing is make sure that in that subdivision that seller can actually lease out the property. There are certain complexes and subdivisions where leasing is not allowed at all, or leasing is allowed but only a certain percentage of the homeowners can lease out their homes, and that percentage may already have been reached. Also, definitely a new potential landlord needs to check with their hazard insurance company. There are special insurance needs for renting out property. Definitely, there's information in here guiding a seller, potential new landlord, to do background checks, be really careful about the contractors they hire, have a written lease. Hopefully that's obvious to you as an agent. Possession of the property belongs to the tenant. This is very important. Georgia law generally provides that possession of the property belongs to the tenant and not the landlord once the lease commences, except to the extent as otherwise provided in the lease. Therefore, landlords and agents do not have the right to inspect the property, put up a for sale sign or a for lease sign, or show the property to another prospective tenant once it's already leased, unless the existing lease specifically provides for that. So that's something very important to know. Just because a person owns the property, once there is a lease signed and a tenant in there, unless the provisions are specifically written in that lease, the landlord does not have the authority to just go into that property at any time. Fair housing laws, those definitely apply to rentals. Okay, here's another one. This is very important. The landlord cannot delegate repairs to the tenant. So if there's repairs that have to be done to the property, and even if the tenant requests it, the tenant says, hey, I'll fix this if you'll give me, a break on the rent for this month. Can't do it in Georgia law. Georgia law requires landlords of residential properties to perform all repairs on the property. While tenants can be asked to perform maintenance, they cannot be asked to make repairs, even if they're willing to do so in the lease. So that's Georgia law. That's something that all landlords and tenants need to know as well. If you have a tenant that's very proficient at a certain skill, they cannot get money off of a lease for doing repairs to their own property that they are renting. There are also specific Georgia mandated procedures that are applicable to landlords. Basically, once a past client or somebody that becomes a landlord, then the Georgia landlord-tenant laws fall into place, and those must be adhered to. Move-in inspections. This, I hope that you as an agent know this if you have ever done tenant procurement for any kind of lease or represented any type of landlord in a lease. But basically, the law states that unless a landlord is exempt from the requirement, the landlord must give the tenant a list of comprehensive list of any damage to the property prior to, now I know you're thinking prior to the tenant moving in, prior to the tenant giving the landlord a security deposit. So the landlord should not accept a security deposit until that move-in inspection procedure has been done and the documentation signed by the landlord and the tenant. For the move-out procedures, same thing. There should be a list of the damages to the property written 3 days after the date of termination of occupancy. All kinds of laws regarding deposits and returns of security deposits. Not following state mandated procedures can have serious negative effects. And evicting a tenant is not necessarily a quick process. Sometimes it can take up to a year to actually get an eviction, to evict a tenant. Certain military personnel can get out of leases early. That is a provision under both state and federal law that, if a military personnel gets called to duty or something along those lines, they can break their lease under no penalty. Same thing with real property, selling real property regarding lead-based paint disclosures. If the property was built prior to 1978, the landlord is also going to need to disclose any lead-based paint issues and just use that lead-based paint disclosure. And tax-wise, financially, a landlord may have to pay capital gains tax. You as a real estate agent are not a licensed tax professional, and so definitely you would want to defer that person to their accountant. And basically, the person just needs to be realistic, deciding, do they in fact want to put this property up for lease or stay in it or sell it and have you list it. Thanks so much for watching. Again, Dana Sparks, broker with Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.